For decades, consumer credit has lived inside a strict, highly structured cage, governed by laws like the Truth in Lending Act. Commercial finance, on the other hand, has operated in a wide-open landscape, a true buyer beware environment, with virtually no regulatory barriers. But over the past few years, states like California and New York have actively pulled commercial products into that strict framework, forcing consumer-style protections onto business-to-business deals. On June 16, 2026, Governor Phil Scott signed House Bill 648, now Act 142, bringing New England directly into this expanding regulatory net. The commercial financing requirements take effect on July 1, 2027. By that date, anyone funding Vermont merchants must tear down and rewrite their standard paperwork, or their contracts become legally void. Alternative financiers must now rebuild their entire operational framework, recalculating how they disclose costs and restructuring how they secure their interest in recipient accounts. Act 142 hones in on two specific financial products: sales-based financing, where deals are repaid as a percentage of revenue, and factoring, where a provider purchases accounts receivable. This flowchart maps out a standard commercial origination chain. Under the new law, padlocks snap into place on both ends of the transaction. The ultimate funder, and the third-party broker sourcing the deal, must now hold a Vermont lender or loan solicitation license. There are specific carve-outs, as you can see bypassing the main flow here: traditional depository banks, government agencies, sellers financing their own goods, and any single transaction over $1 million are exempt. But if your firm falls outside those narrow exceptions, you need the license. Shielding a commercial lending operation behind a network of independent brokers will no longer protect you from state oversight. The physical contracts must also be gutted, specifically targeting three major clauses found in standard form agreements. First, any commercial financing contract containing a confession of judgment provision is now entirely void. These fast-track legal remedies are completely off the table. Second, any dispute with a Vermont recipient is governed exclusively by Vermont law and must go to Vermont courts. Out-of-state arbitration clauses are unenforceable against the recipient, and the provider is now legally required to pay all arbitrator fees. Third, providers can no longer automatically debit a recipient's deposit account to collect payment unless they hold a validly perfected first priority security interest. Vermont lifted that specific auto-debit restriction word for word from Texas law. Regulators in Texas interpret that phrasing to mean a provider needs a first priority claim on the merchant's actual accounts receivable. If Vermont adopts that same reading, standard ACH repayment structures become heavily complicated. Taking a generic national commercial contract and putting it in front of a Vermont merchant guarantees an unenforceable deal. The most difficult operational hurdle happens before the contract is even drafted. Vermont now requires TILA-style estimated APR disclosures to be signed the moment a specific offer is presented. You cannot use a single unified disclosure template. As this diagram shows, the compliance math splits into two completely different paths depending on the exact product. Following the sales-based path, the provider has to calculate an estimated APR using the federal regulation Z method. This means projecting the exact term and payments based on a specific sales volume curve. Over on the factoring side, the formula changes. The agreement is treated as a single advance transaction, and the discount taken on the face value of the specific receivables acts as the isolated finance charge. Building a compliant sales pitch now means hard-coding entirely distinct mathematical rules into the front end of the origination process. The open, buyer beware market for commercial finance in Vermont is officially closed. While the July 2027 effective date seems far away, the statute applies to any contract modified, amended, or restructured on or after that date, pulling renewals of existing deals immediately into scope. Businesses need to start their internal audits right away. That means checking licenses for every link in the origination chain, stripping confessions of judgment from the boilerplate, and coding the dual disclosure calculators. Legal teams must also monitor the Vermont Commissioner's upcoming rulemaking sessions. Those rules will ultimately decide how strictly the state applies the Texas-style restrictions on auto-debit payments. Surviving this legislative shift requires businesses to start disassembling and rebuilding their legal infrastructure today. Waiting until the 2027 deadline ensures a complete lockout from the market.